Hello everyone, a very good morning. Welcome to the CAIIB November-December mini marathon for your BRBL paper, and today we'll be covering our module D. So the module D, which is very important for our exam, the commercial and other laws with reference to banking operations. So the various important acts like the Indian Contract Act, the Sale of Goods Act, the Companies Act, Partnership Act, Limited Liability Partnership Act, Right to Information, the Prevention of Corruption Act. These are the topics that are covered here in Module D. Module D is extremely important when we talk about the case studies. Many case studies are framed from the contracts, from the Sale of Goods Act. So you need to study it accordingly. So let us start. We'll be following the same thing. I'll be giving you questions on the screen, 10 to 15 seconds to answer, and then we'll be discussing the correct answer. All right, so let us start with our first question of module D. Okay. Which of the following correctly describes the fundamental requirements, foundational requirements for a valid contract under the Indian law? Read the statements. An agreement made between parties who are competent and acting under free consent is always valid regardless of object or consideration. A valid contract must arise from lawful consideration with consensus ad idem and cannot be expressly declared void by the act. Oral agreements are always enforceable in law, even if formal registration is required under another statute. An agreement not enforceable by law, though made with free consent and lawful object, remains a contract until it is challenged in court. So, what is a contract? A contract between two parties, right? It can be made when a promise is made by one party to another, and then there are certain provisions to make that promise legally binding on them. So this mechanism is the law of contract, right? The various essentials that would make a promise and agreement into a contract. So contract is simply, it is an agreement when it also has enforceability by law. So contract is agreement plus enforceability. It should be made by free consent of all parties. The parties should be competent to contract. It should be made for a lawful consideration with a lawful object and should not be declared void expressly in the Indian Contract Act. Right? These are the key components, the essentials for a contract to be valid. So the first statement accordingly should be incorrect. Why? Because we are talking about the statement says there is no need for a lawful consideration. So the first statement is incorrect. Second statement is correct. It should be a lawful consideration, consensus, and it should not be expressly declared void. Third, oral agreements are enforceable, but if some other act, some other law says that formal registration is required, it will have to be followed, like the Transfer of Property Act. And an agreement not enforceable by law will not be a contract, right? If it is not enforceable, it means it is void ab initio. Certain things are declared void in the very beginning in our act. That is void ab initio. Right? So the correct answer is only statement 2. So the correct answer is option A. Alright, only the second statement is correct. So you need to understand the essentials of a valid contract. Proposal and acceptance should be there, intention to create a legal relationship, lawful consideration should be there, right? Okay, so next. Select the correct statements. A continuing guarantee cannot be revoked by the surety as to the future transactions by notice to the creditor. Any guarantee obtained by the means of misrepresentation made by the creditor is invalid. In every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. When there are co-sureties, a release by the creditor of one of them does not discharge the others. Now, what is a contract of guarantee? There are many contracts that are given in your syllabus: indemnity, bailment, pledge, agency, and guarantee. Guarantee simply means there are three parties involved, right? There is the principal debtor, there's the creditor, the principal creditor or the beneficiary, and then there comes the third party, which is the surety. The contract of guarantee simply means when the person who is the principal debtor, they incur a default. In their case, the surety is going to step in their shoes. All right. Yes. So, if we are talking about a continuing guarantee, a guarantee which extends to a series of transaction, it is not limited to only one transaction but to many transaction. When it is continuing, it applies from time to time, right? And it can also be cancelled, right? If the guarantor, if the surety they want, it can be revoked by giving a notice to the creditor that no longer I am providing my guaranteeing services. So the first statement is incorrect. Second statement, misrepresentation, correct. In every contract of guarantee, there's an implied promise, yes. That is, if the surety is paying on behalf of the principal debtor, the surety can sue the principal debtor later on to receive whatever is owed. So they are going to step in the shoes of the creditor now. And when there is co-surety, release of one creditor, correct. If there are, let's say, two sureties A and B, one person is released, the other person still has the liability, they still hold the position as the surety. So the correct answer should be D, 2, 3, and 4. 2, 3, and 4. All right, a continuing guarantee can be revoked by the surety as to the future transaction done after the receipt of notice of revocation, right? Any guarantee by the means of misrepresentation is invalid. If the guarantee the creditor has obtained by keeping silent certain material circumstance or information, it will be invalid. It is an implied promise. Only a valid guarantee is going to be an implied promise. Okay. Select the correct statements about the roles in the bailment. Now, when we are talking about bailment, what is bailment? There's the bailer and the bailee. The bailer is the person who is the owner of the goods. They do what? They hand over the possession of the movable property to the bailee for a specific purpose, right? And when the contract is over, then the time is over, it will be returned or disposed in whatever manner has been agreed. So the person delivering the goods is known as the bailer, and the person receiving the goods is known as the bailee. So there's the bailer bailee relationship. All right, so the person to whom the goods are delivered is the bailee, and the person delivering the goods is known as the bailer. So the correct answer is B and C. And remember, bailment is different from pledge. Pledge, the possession is given for to keep it as a security. In the bailment, for a particular purpose to be used. All right, the goods are to be used, let's say cotton to be used to produce textile clothes, or some machine to be used for any production purpose. Now there are the duties of the bailer and the bailee. The bailer is bound to disclose any material information, any faults in the goods that could cause loss to the bailee. The bailee is required to take care of the goods that are bailed to them, right? If they do not take care and there is loss or destruction or deterioration, the bailee will be responsible. All right. Next question. What characterizes as an absolute contract for the sale of goods? Now we are talking about the Sale of Goods Act of 1930. The contract can be specific contract, it can be absolute contract. All right. So what is the meaning? Is it where the conditions must be fulfilled by the seller? No conditions need to be fulfilled by the seller or the buyer. Conditions must be fulfilled by the buyer, or the conditions need to be negotiated after the sale. So when we are talking about goods, they are movable goods, stocks and shares, growing crops, things attached to the land, but it can be separated before sale. Buyer, seller, price, delivery, document to the title of goods, the bill of lading, dock warrant, warehouse keeper certificate can be there. Future goods that would be prepared, manufactured or produced or acquired by the seller after making the contract. Specific good, mercantile, these are the things. When we are talking about an agreement to sell, it becomes a sale when the time elapses or the conditions are fulfilled. When there are certain conditions to be fulfilled, it is a conditional contract. But when we are talking about an absolute contract, there are no conditions need to be fulfilled by the seller or buyer. So the contract can be absolute or it can be conditional. There are no conditions in the absolute contract, but in the conditional sale, the parties are there impose some conditions. When they are fulfilled, only then the contract of sale will be fulfilled. All right. Now, there's also the difference between condition and warranty. Okay, that is also an important thing. Sale and agreement to sell. Agreement to sell means the parties they have written down something, they have agreed to buy and sell the goods, but they are required to perform their mutual promises. When those mutual promises have been performed, then the agreement to sell will become a sale, where the ownership will be passed from the seller to the buyer. The risk will be with the buyer now. All right, that is the difference between sale and agreement to sell. Okay, which of the following statements validly apply to the doctrine of resale and subsale in the context of an unpaid seller? What are the rights of an unpaid seller? This is a very important topic. Unpaid seller means the goods are delivered to the buyer, but the buyer is refusing to pay. So there are certain rights that the seller has against the goods as well as against the buyer personally. Against the goods, they have the right to lien, stoppage in transit, resale the delivery. Where the goods have not passed in possession, they can withhold in transit and stoppage. Against the buyer, they can file a suit for the price, suit for the damages, repudiate the contract. They can sue the buyer for the interest as well. All right, so let us see the statement. The unpaid seller's right of lien or stoppage in transit is unaffected by a subsequent sub-sale or pledge made by the buyer without the seller's consent, unless the documents were transferred in good faith. Is it true? Yes. If let's say the buyer they subsold the goods, right? The person who received those goods were in good faith for the value, so their right will be unaffected. But the unpaid seller can recover their price from our buyer, right? Their right of lien stoppage will remain unaffected. If the unpaid seller gives notice of resale and then the buyer fails to pay in reasonable time, the seller is entitled to recover damages. Yes, if the unpaid seller gives the notice, they are entitled to recover damage, retain any profit. But if they do not give the notice to the buyer before selling off the goods, then they cannot sue the buyer for the interest, any profit. They will have to return the profit and they cannot sue the buyer for any recovery of damages. If no notice of resale is given, the unpaid seller forfeits the right to damages. Yes. Fourth statement, resale by the unpaid seller after exercising lien or stoppage confers a defective title on the new buyer If the notice was not given, no. The new buyer's rights will remain unaffected. All right, so the fourth statement is incorrect. Even without notice, the new buyer requires the goods, though the seller loses the claim to damages. If they do not give the notice to the original buyer, they are only going to lose their claim to damage, but the new buyer's right will not be affected. All right? Yes. Okay, so these are the points that you need to remember. Which of the following statements are correct with respect to the rights and liabilities of a minor admitted to the benefits of a partnership? Can a minor be admitted to the benefits of the partnership? Yes, but only the benefit. The minor has the right to share the profits and the profitability of the firm as agreed upon by the partners. They can also have the access to the documents of the firm. But the minor will have the share, they will be liable for the acts of the firm. They will not be personally liable for the acts of the firm. Only the minor's share will be liable. The minor is not personally liable for the acts of the firm, any liabilities arising from it. The minor may or may not take legal action against the partners for the payment of his share of the property. All right. So this is the relation. The minor has the right to access the firm and to share the profits. Yes. The minor's personal assets are liable. No. The minor may sue for his share of the profit only when electing to sever connection from the partnership firm. Is this statement correct? Yes. Right? And the fourth statement, a minor cannot be admitted to the benefits of an illegal or void partnership. It is true and in principle, but the illegality doctrines do not work here. So if the minor had idea that this is a void and illegal partnership, still they become a partner, then it will be valid. All right, so the correct answer should be B, 1 and 3 only. Okay, 1 and 3 only are correct. 2 and 4 are incorrect. What about what is the legal position of the minor after they attain the age of majority? They have to give a notice whether they want to continue as a partner or not, a public notice, right? If they fail to give the notice, they will automatically become a partner of the firm on the expiry of the 6 months. So when they attain the age of 18, within 6 months, they need to give a public notice, right? If they fail to give the notice or they give the notice that they want to become a partner, the rights and liabilities as a minor continue up to the date on which they become a partner, but now they will also become personally liable to the third parties, right? If the person elects not to become a partner, then up to the age of minority, their rights and liability will continue, right? Their share will not be liable for any act of the firm after the date of the notice, and they shall be entitled to sue the partners for the share of the property if they want to leave. All right. Which of the following statements are true regarding the amendment procedures of the memorandum and articles of association? Now, if we want to make a change in the memorandum or articles of a company, what can be done? The alteration of the MOA for shifting the registered office from one state to another requires central government approval. The company may alter its articles by passing an ordinary resolution in a general meeting. The articles of association can never override statutory provisions. The MOA can only be amended if permitted by both a special resolution and approved by the NCLT. Now, MOA and AOA are two very important public documents. The first step in the formation of the company is the preparation of the MOA. The name clause, if the company is limited with liability, the last one should be limited. And in case of a private company, it should be private limited. Registered office clause is there. Only the name of the state is required to be mentioned, right? Objective clause, the main objective, other objective, the liability clause, capital clause, association or subscription clause. Article of association is the secondary document, the rules and regulations, the bylaws for the internal management of the company. All right, the internal management of the company. So, the memorandum of association contains the fundamental activities. The clauses in the memorandum can be altered only by a special resolution passed by the company, not with a ordinary resolution, and it should be approved by the central government. The article of association can be altered by a special resolution, but no approvals are required from the central government or any other authority. All right, so the correct answer will be C, 1 and 3 only. All right, not by an ordinary resolution to alter the special articles. We also need a special resolution, just a government approval is not required. Okay, and approval from central government, not NCLT. So the correct answer is C, 1 and 3. Okay, which of the following correctly represent the statutory mandates relating to the directorship limits and vacation of office under the Companies Act of 2013? A person can hold directorships in a maximum of 20 companies at a time, of which not more than 10 may be public companies. A whole-time director can be appointed for a term not exceeding 5 years, with reappointment permitted at any time after appointment. The office of the director shall become vacant if he is convicted and sentenced to imprisonment for 6 months or more, even if an appeal is pending. If a director is absent from all board meetings for 12 consequent months without leave, he vacates the office. Directorship, another important topic. Who can become a director of the company? What is the eligibility, the minimum number of directors, filling of the casual vacancies, maximum number of directorships, all of these topics are important. When we are talking about the minimum number of directors in a public company, there need to be three. Two in the case of the private company and one in the case of a OPC. When we are talking about maximum 15 directors can be there. One director should be a resident in India, right? Every listed company shall have at least one third as independent director. The central government may prescribe the minimum independent directors. Okay, so these things are there. If we are talking about the correct answer is A, 1, 3, and 4. All right, the second is incorrect because the appointment cannot be made earlier than 1 year before expiry of the term. All right, reappointment is permitted at any time after appointment. No, a cooling off period is given. All right, the director, any person who wants to become a director should not have a substantial interest in any other company. Appointment of the director, retirement by rotation is another important topic, right? These things are there. Other points are correct. Okay. Which of the following are valid statutory grounds for the dissolution of a partnership firm by the court under Section 44? When will a firm be dissolved? For what reasons can the partnership firm be dissolved? A partner has transferred their entire interest in the firm without consent. A firm's business can only be carried out on a continual and unavoidable loss. A partner persistently violates the provisions of the Indian Contract Act of 1872. It is just and equitable to dissolve the firm due to a general deadlock or loss of mutual trust. So, when we are talking about the dissolution of a partnership firm, when can it be dissolved? So, what should be the correct answer? the dissolution of the firm is different from the dissolution or secession of the partnership, right? A partner ceases to be a partner. A person ceases to be a partner in the LLP on their death or dissolution of the firm if they're declared to be of unsound mind, or they have applied to be adjudged as an insolvent, or they're declared as an insolvent. But when we are talking about dissolution of the firm, the first, second, and fourth statement are correct. When a partner persistently violates the provisions of the Indian Contract Act, they can be removed. They can be removed as a partner, but it will not dissolve the firm. All right. The persistent breach of the partnership agreement, not the contract act, is general. Only when the partnership agreement is breached, then this situation can be there, otherwise not. All right. So this is the correct answer. Next, which of the following conditions must be fulfilled for the LLP to be validly incorporated under the section 11? The incorporation document must be signed by at least two individuals associated for carrying on a lawful business. The declaration must be filed by an advocate, CA or CS, or a cost accountant engaged in incorporation, and at least one subscriber stating the compliance with the act. The LLP agreement must be filed simultaneously with the incorporation document to be valid. The incorporation document must contain the registered office address and names of all the partners and the designated partner. So, for the incorporation of the LLP, when we are talking about the Limited Liability Partnership Act of 2008, right? What is it? It is a body corporate. It has its existence separate from the partners of the firm. Certain characteristics are similar to the company, right? There are partners as well as designated partner who are appointed. Designated partner, every LLP shall have at least two designated partner, and individuals, at least one of them should be a resident in India. There are liabilities and changes in the designated partners as well. When we are talking about the incorporation document for the LLP, two or more associated persons for carrying on a lawful business with a view to share the profit shall subscribe to the incorporation document. It should be filed in the manner with such fees as prescribed by the registrar of the state where the LLP is to be situated. There shall be filed with the incorporation document a statement which should be made by the advocate, CS, cost accountant, correct, that everything given in the document is true. The incorporation document, if anything is false or any misrepresentation is done, then this person giving their consent will also be liable, punishable with imprisonment for a term that can be extended to 2 years, and a fine not less than 10,000 rupees extended to a fine of rupees 5 lakh. Right? So that is why the CACS approval is required. So the correct answer is C, 1, 2, and 4 only. It should not be simultaneously filed the agreement with the incorporation document. All right, it can be given separately as well. All right, what will be the effect of registration? Now the partnership will be capable of suing and be sued. They will be able to acquire, hold property, dispose of property. They will have a common seal if they decide to have one. They can do acts, anything that a body corporate is lawfully able to or allowed to do. All right, so the correct answer is 1, 2, and 4. Okay, filing of the LLP agreement is not a condition for incorporation. It must be filed within 30 days of incorporation. All right. Here's a case study. Zeta Associates LLP was incorporated with two individual partners and one body corporate. One of the individuals designated partners, Mr. Verma, resigns. leaving the LLP with only one designated partner who is a non-resident Indian. The remaining corporate partner nominates Mr. Rai as an individual to fill the vacancy. Mr. Ray provides consent in the prescribed form and applies for the designated partner identification number. However, the LLP does not file the appointment particulars with the registrar within the required timeline. Considering the provisions, which of the following statements is most accurate? The LLP is in compliance since it has two designated partners post nomination. The appointment of Mr. Rai as designated partner takes effect immediately after consent, regardless of filing. Mr. Rai cannot be nominated by a corporate body under any circumstance. The LLP is a violation due to the lack of the resident Indian as a designated partner. Each and every point we have already discussed. I told you that designated partners should be there in the LLP, right? Every LLP shall have at least two designated partners, and one of them should be a resident in India. But the Mr. Verma resigning, and the only person remaining is a non-resident. So the LLP is a violation due to the lack of a resident Indian as the designated partner. All right. The designated partner, one of them should be a resident. This is a very important point for the LLP. So it will be void. Okay. Which of the following statements accurately describe the concept and transfer of actionable claims under the Indian law? Actionable claims include debts secured by a mortgage or pledge. A beneficial interest in movable property not in possession may qualify as an actionable claim. The transferee of an actionable claim must issue formal notice to the debtor before asserting the rights. The transfer of actionable claim requires execution of a written document signed by the transferor. So, when we are talking about the Transfer of Property Act of 1882, we have already discussed about the various types of mortgages. Actionable claim means a claim to any debt other than that secured by a mortgage, hypothecation, or a pledge. It can be a beneficial interest in movable property, not in possession, where the civil court recognizes as giving relief. All right, so that is why it is a claim that is actionable in the civil court. Transfer of the claim can be done with or without consideration only by the execution of an instrument that should be signed by the transferor. All right, there is no mandatory requirement of giving notice to the debtor before the transfer, but the written consent by the transferor should be there. And the transferee of the actionable claim can sue the debtor in their own name without obtaining the transferor's consent. All right, so debtor not required, right? Debtors formal notice giving a formal notice to the debtor is not required, but execution of the written document signed by the transferor is required. So the correct answer is 2 and 4 only. Actionable claim includes a claim other than a mortgage, hypothecation, or a pledge. Okay, so the first statement is incorrect and the third statement is also incorrect. Notice to the debtor is not a legal consideration. So let's say an actionable claim was owed by A, they are the transferor, they transfer it to B, the transferee, and C, who is the debtor. Giving notice to the debtor not required, but a written consent that the transferor is transferring it is required, and the transferee can now sue the debtor without involving the transferor. All right, without giving them a notice, without making them a part of this execution. All right. Which of the following disqualify a person from being appointed as an independent director? Now, independent directors of a company is also important. The person is related to a promoter of the company's holding or associate company. person has held more than 2% of the total voting power along with relatives. The person was a key managerial personnel of a company 2 years ago. A relative of the person has a pecuniary transaction owing to 1% of the gross turnover. Now, when you are reading these statements, look at the important points. Like I am marking the important things. 2% of the total voting power, 1% of the gross turnover, like this. So, which situation will disqualify a person to be appointed as an independent director? One are valid bars, right? If a person is related to the promoter, they cannot be appointed. Second, a person again cannot be appointed if they are holding more than 2%. But the third statement will be incorrect. Why? Because the lockback period is not 2 years, it is 3 years, right? They will be disqualified if they have a key managerial role in 3 financial years. Fourth statement is also incorrect. Not 1% of the gross turnover, but 2% of the gross turnover. All right, 2%. So the correct answer will be 1 and 2 only. All right, 1 and 2 only. All right, I hope this is clear. Okay. Which of the following categories of information are exempt for disclosure under the RTI Act 2005? Information relating to the breach of parliamentary privilege or contempt of court? Yes. If information is confidentiary information relating to the parliamentary decision, the information can be rejected. Information held in fiduciary capacity, correct. If any information is related to the integrity of the nation, to the army, to the security, it can be rejected. Information that cannot be denied to parliament cannot be denied to any citizen, true. If any information can be given to the parliament, it has to be given to a person making the claim. Trade secrets and intellectual property that could harm the competitive position unless public interest. All of these statements are true. All of this information is exempt from disclosure. All right. So the public information officer, they can reject the application made by a person because these informations are exempt. All right. So now there's a whole procedure for obtaining the information. First point, every public authority should maintain all the records in the public access, the particulars of the organization, powers and duties of the officers and employees, the norms for the discharge of its functions within 120 days from the enactment RTI Act 2005. They need to publish it. Then, what is the procedure for obtaining information? The public information officer is going to receive requests from the person seeking information, right? And they will have to give the information unless any disqualification or exemption is there. Okay, so the correct answer is D. All of the other above are exempt. Okay. Ritika sells a bulk shipment of coffee beans to Ajay and hands it over to Transline Logistics for delivery without reserving the right of disposal. Before delivery, Ajay defaults on prior payments and is declared insolvent. Ritika wants to assert her line. Now, here the most important point that you need to focus on is that without reserving the right to disposal. Now, what is the remedy available to Ritika? She can enforce her lien over the goods in transit. She can sue the buyer's agent who took delivery. She retains both lien and stoppage until the title passes. She can exercise stoppage in transit as the lien is lost. What is lien? Lien means physical holding of the goods. But Ritika has delivered, they have handed it over to Transline Logistic to delivery. Ritika has lost the transit. It is in the delivery process. During the delivery process, it comes to her notice that Ajay has been declared insolvent. Now they cannot exercise lien, but they can exercise stoppage in transit. Whoever is carrying the goods to the buyer, they will stop the transit and it can be called back. The delivery can be called back. All right, but the lien is lost. So the correct answer is D. Which of the following statements correctly apply to the doctrine of indoor management? Now, there are certain doctrines like constructive notice, indoor management, and they are again very important. All of these doctrines of ultra wires, what is intra wires? Okay, so it protects the outsiders dealing with the company from liability arising due to internal procedural lapse. It presumes that a person dealing with the company has read and understood its internal resolution and board decisions. It can be invoked only if the outsider's contract is consistent with the memorandum and articles. It imposes a duty on the outsiders to inquire into the company records filed with the registrar to verify the internal compliance. First statement is true, right? The person who is dealing with the company are required to read the MOA and AOA. True. It is also assumed that they have not only read but understood each and every point. But the internal regulation need not be inquired by them. All right. So let's say a person, they entered into a contract with a company ABC, right? And the contract was the delivery of some precious metal. Now the MOA said that delivery of precious metal can be done. The AOA said that the delivery of precious metal will be done with the consent and voting of all the directors, of all the designated directors. The company, when one person, let's say Mr. X, who was the designated director, they came into a contract, they delivered that they are going to deliver the goods. And the buyer, they made the payment. Later on, it was found that this person, Mr. X, did not take consent of the other directors. And they said that we are going to repudiate the contract. This cannot be done because the MOA and AOA was read, and after that the buyer entered into the contract. The internal regulation is not an issue of the buyer. So it does protect the outsiders dealing with the company from the liability due to internal procedural lapses. True, right? First statement is true. Second statement is incorrect. The internal resolutions need not be inquired. It presumes that the person dealing with the company has read and understood the MOA and AOA, but the internal resolutions, not their duty. Fourth statement is also misleading, right? The duty arises under the constructive notice that they need to understand it, the MOA and AOA. But whether the internal records or the regulations are fulfilled or not, it is not there. All right, so the correct answer should be A, 1 and 3. All right, let us recall these doctrines. Ultra wires means beyond the powers of the company, something which is outside the scope of the MOA. Intra wires means within the powers of the company. It is related to the objective stated in the MOA. Right. Now, when we are talking about the ultra wires transaction, what would be the effect of ultra wires transaction? It is void ab initio. No company can be held liable for the obligations arising out of such a contract. So, if a company very clearly says in the memorandum of association that its objective is to deal with manufactured processed gold, right? Gold jewelry, but the company is coming into a contract with the raw gold, precious material, right? Or the ore. So this will be a ultra vires transaction. If a buyer comes into a transaction or contract, the buyer cannot claim any damages. All right. Protection is given to the buyers through the indoor management. The principle of constructive notice, it protects the company against the outsiders. Indoor management protects the outsiders against the internal mismanagement. All right, so these are the doctrines. Okay. Which of the following statements accurately reflect the statutory provisions governing the critical information infrastructure? A computer resource whose incapacitation affects public health or safety may be declared as a part of critical information infrastructure. Is it true? Yes. If it is, if the breach of this computer system could harm the public interest, it is a critical information infrastructure. Unauthorized access to a protected system constitutes a criminal offense. Again, it is true. Imprisonment up to 10 years and a fine. Only the central government may notify? No. Even the state government has the authority to notify a computer system as protected. The central government may specify security practices. Yes. So the correct answer is 1, 2, and 4. All right. Now, when we are talking about the Information Technology Act of 2000, there's the critical information infrastructure. The appropriate government will declare any computer resource to be a protected system. The appropriate government, the person who then secures access or attempts to secure access in contravention of the provision, will be punished with imprisonment and a fine. Right? The national nodal agency will be responsible for all the measures, research and development for the protection of the critical information infrastructure. So you need to remember the national nodal agency. All right, the adjudicating officers. Okay. Next, which of the following statement is incorrect for the classification of offenses and punishment under the Prevention of Corruption Act of 1988? The bribery by a public servant under Section 7 attracts minimum imprisonment of 3 years, may be extended to 7 years and a fine. A person attempting to commit criminal misconduct, imprisonment for a period not less than 2 years, extended to 5 years with a fine. Habitual offender, punishment not less than 5 years, extended to 10 years and a fine. Bribing a public servant through a commercial organization, punishment punishable with a imprisonment of 3 years. Now, when we are talking about the Prevention of Corruption Act, there's a whole table that is given to us. When the public servant is bribed, punishment is imprisonment not less than 3 years, extended to 7 years, true, right? When a person gives undue advantage, again extended to 7 years. Person who is bribing a public servant by a commercial organization, punishable with a fine. But when we are talking about the bribing of a servant through a commercial organization, right, it is only punishable with a fine, not imprisonment. This is what, this is the section 9 of the Prevention of Corruption Act. Offense relating to bribing a public servant by a commercial organization. It cannot be imprisoned, only a fine can be imposed. Other three statements are correct. Which of the following powers must be exercised by the board of directors only through resolutions passed at duly convened board meetings? Making calls on shareholders for the unpaid share capital, approving a scheme for amalgamation, investing surplus funds of the company, contributing to the political parties within the prescribed limit. See, political contributions are not mandatorily requiring any board meeting. Disclosure is essential. Whenever a company is contributing to the political party, it is important to make a public disclosure how much is their contribution. Other than this, everything requires board of directors to hold special meetings and then they should exercise their rights. All right, so the correct answer is 1, 2, and 3. 1, 2, and 3. Last question. X limited articles of association authorize the directors to borrow money, but only with the shareholder approval via a resolution. Mr. A, who is a supplier, delivers goods rupees 50 lakhs to X Limited on the basis of a bond issued by the director. Mr. P later, the company refuses to honor the bond, claiming that no such shareholder resolution was passed and hence the transaction was unauthorized. Mr. A had no knowledge of this internal requirement and acted in good faith. We have already discussed the doctrines: constructive notice, ultra vires, and indoor management. So here the scenario is saying that Mr. A came into the contract knowing the MOA and AOA, that such a contract would be entered only by the shareholder resolution. Later on, it was found that shareholder resolution was not there. So what is the correct answer? Mr. A cannot enforce the bond because he failed to verify resolution. No. Internal resolution, internal inquiry is not required. Mr. A is protected under the doctrine of constructive notice as he could have read the articles. No. Doctrine of constructive notice only talks about the external things, not about the internal management. Mr. A is protected under the doctrine of indoor management. Yes, they can assume that the internal procedures were followed. And Mr. A is not liable for investigating the company's internal approval. So the correct answer is C. All right, so these are the most important topics from the module D. There are many other topics, right? We will be covering them in the further YouTube sessions. We have completed all the 4 modules of in this mini marathon series. After this, we'll be having the other marathons in which we'll be discussing the leaving topics. All right, so that is all for today. And your exams are very close now, so do not delay, do not procrastinate. Join the CIB Super Elite all-in-one plan where you'll be getting access to all the classes, foundation, practice, advanced, everything. You'll be having access to the case study, numerical, and elective paper tests. 140 plus chapter wise summarized notes. We have also started with the revision, the CAIIB all in one combo, the crash plus cracker batch. So enroll now. The live classes are going on a daily basis. We are practicing. We are right now covering the crash batch. After that, we'll be starting with the cracker. So make sure that you enroll and join the live classes and prepare for your exam. And do not forget to subscribe to the YouTube channel because after this, we'll be having the mega marathons in which we'll be practicing more such important questions and case studies. So, like the video, share the video, and subscribe to the Oliveboard JIB CIB English Medium channel. And I will see you in further such important sessions. Thank you and all the best.